Greetings, everyone. I know we have attendees joining from all across the United States and also a few international attendees as well, so welcome to you all. Thank you for joining us for this webinar. My name is Akshat Divatia. I am an immigration attorney. I have been with Harris Bricken since 2017. Our firm's immigration practice encompasses advising and counseling clients, corporate clients typically, on attracting and retaining foreign-born talent. We also provide service to non-citizens in their non-immigrant and immigrant visa application needs. And of course, as you will discover, and that's the reason why most of you have joined, is to understand how we can help litigate on behalf of our clients when things don't go as well as hoped with U.S. immigration agencies. So we do have a lot to cover today, and the hope is that we still have about 10 to 15 minutes for questions. I know many of you have provided questions, and we will do our best to answer. But don't hold off on asking us questions. If we see something that we would really like to speak on, then we might pick one of those questions over the course of this webinar. So we're going to talk about a bunch of things, essentially, from an overview of the Administrative Procedures Act, which is the legal statute under which a federal lawsuit can be filed, to the fundamental issues of standing, who can sue, venue as to where that lawsuit can be brought. You also have, issues about, the procedural considerations, what needs to be done when, and also navigating interagency politics. So we're going to talk about all of that, and then, I do want to mention, though, that this is, as comprehensive as this field is, we don't have the time to cover everything as it relates to federal lawsuits for immigration purposes during the course of this particular webinar. We hope, and we're planning actually on having another webinar in the future where we can take mandamus lawsuits, among other things that we are not able to fully cover in today's session. So before I get started, let me introduce my colleagues. You have Jack Scrantom, to your left, and Tom Oster. They will provide us with their insights on litigating these immigration cases. Jack practices both business and immigration law, and he has extensive experience working with companies in terms of their non-immigrant and immigrant visa needs, both in terms of skilled and unskilled laborers. And then, of course, Tom is a seasoned commercial litigator. He has extensive experience, litigating on regulatory issues, appellate issues as well, and he is licensed in both California and Washington. And we turn to him, and he has played an instrumental role in the case that we're going to discuss today. So, I'd like to just kind of provide a little bit of a landscape before I turn it over to Jack and Tom. The main issue to keep in mind here is that we're here because we run into a rise in number of lawsuits, and so for those of you who've been following this, I'm going to actually see if I can share my screen, and I hope that people are able to see this. And what you see over here is that you have lawsuits that were just over 1,000 in 2015 fiscal year. And as you see the rise of these lawsuits, especially in the last 2 or 3 years, what that tells you is that there is something's not going right vis-a-vis the U.S. Immigration Service. This is in a reasonable world. The cases would be processed on time. The stakeholders would be given the opportunity to provide evidence, and for that evidence to be would be reviewed. There would be opportunity to respond if something is deficient, and of course the decision making would be based on the weight of the evidence, not against that weight of evidence. So in the last few years, what we've noticed is that the agency decisions have become even more arbitrary, even more capricious. The delays are extensive, and so lawsuits have become the tool that many practitioners and many clients, corporate and individuals, rely on in order to change the course. Patience runs thin after having waited for months and months, if not years. It's also important to understand that the rise in lawsuits is because lawsuits work. You're looking at a litigation process. You generally don't go into that process unless you have a very strong case, unless you are able to show that in the interest of equity, in the interest of fairness, that you deserve a lot better outcome than the one that you're getting, in many cases not getting an outcome at all. So I want to point out three different things that that makes these lawsuits successful. First is timing. Typically government agencies, Department of Homeland Security agencies, have an appellate process where you can appeal an agency decision, ask for requests for reconsideration, but oftentimes those requests fall on deaf ears, because if they were to grant those, then essentially they are negating a decision that they made previously. It is not in their interest to reprimand or to say that they were wrong. Oftentimes these appeals end up rubber stamping the erroneous decisions that have already been made at a lower level. When you contrast that with federal lawsuits, if the cases are not settled in the first few weeks, the maximum amount of time, or the trend, is typically that in about 6 months' time, you will be able to get to a hearing on the merits of the case. Now that's massive, because when you look at a year and a half, 2 years, 3 years of waiting, with essentially a foregone conclusion as to how that appellate body is going to decide, and you contrast that with a third party, a neutral party, who's able to hear the case under proper rules of evidence and is able to make a decision, or in this particular case, as you will see, to compel the agency to do the right thing. The timing is certainly a big factor why people decide to pursue lawsuits. The second is also, risk mitigation. Oftentimes when lawsuits are filed, the defendant agency is at real risk for having to provide a lot of their background documentation as part of the discovery request. And, comparing that to somebody who, who pays a surprise visit to a messy bedroom, the agency doesn't have the time or the inclination to kind of clean house, but at the same time, they do have a desire to make sure that they don't have to show just how much of a mess things are within the agency. And then the last issue is, of course, pride. The federal litigators, the U.S. attorneys who are responding to lawsuits, they are not defending what they do themselves. They're defending on behalf of their clients. Their clients are Department of Homeland Security agencies, and those individuals, the U.S. attorneys don't like to lose, certainly not when it's because of inefficiencies or mismanagement by another agency. So, all that said, that's the backdrop essentially as to why the lawsuits have risen, because of unfair denials, unreasonable delays, and why lawsuits work. So, at this point, I would like to turn it over to Jack and Tom, and I want to talk about, I'll interject with questions as I see them, but I do want to talk about some of the questions that I see also as I come up from panelists. So without further ado, I will actually stop this slide, and I'll let Jack take over.
Thanks, Akshat. And good morning, everyone. I know a handful of you are coming in because of your relationships with either one of the three of us, and some from general marketing. So thanks for coming in and joining this morning. Before I begin, I want to reiterate what Akshat had mentioned, which is that the analysis we're going to discuss here really is highly fact dependent. And it's more broad in both scope and depth than we're really able to fully break down in the time that we have here. Our aim is to discuss some of the high-level gatekeeping questions that we, of course, consider, and that whether you're in the immigration consulting field and you've got a bunch of clients, or you're an immigration attorney or an employer. We want to discuss some of the high-level gatekeeping questions that are important to be considered before you're bringing an immigration-related APA claim. With that said, we believe really strongly that these cases are one of the only ways to really move the needle in the immigration process when things go wrong. And we're hoping that by discussing this stuff with you, you'll be able to identify cases that are worth bringing under the APA and field that stuff appropriately with your clients. So jumping into the APA basics, as Akshat mentioned, there are two primary federal acts that are used to sue immigration authorities, one being the Mandamus Act and one being the APA. The Mandamus Act is different than the APA. It's just used to compel a U.S. federal agency to take action that's been unlawfully withheld or unreasonably delayed, which is, it's helpful under some circumstances, but where USCIS, for example, has just outright made an incorrect decision, which is what took place in the case we're going to highlight. The APA is really the better federal act to bring the case under. I know that plenty of you have cases out there. Just a brief aside on the Mandamus Act, which we're going to try and do another webinar on soon. I know that a lot of you are likely to have Mandamus Act questions because statistically, it's true that many more cases are stuck somewhere in the immigration process that have 6, 7, 8-year delay issues that are not associated with priority date wait times. So those are genuinely worth considering under the Mandamus Act. And more of those cases are out there than those which have been unlawfully adjudicated, which is what we're going to highlight today. So I know that a lot of you have Mandamus Act questions, and we're going to try to do a webinar on that soon. The APA itself allows plaintiffs to ask a federal court to hold unlawful and set aside agency actions, findings, and conclusions that have been unlawfully held. So you can also raise unreasonable delay claims, it should be noted, under the APA as well under certain circumstances. Again, all things unreasonable delay, we're going to hold off for another session. One of the first requirements and gatekeeping questions that we've got to ask when we're looking at these cases is whether or not there has been final agency action. I'm sure we're going to have some questions about this, but generally speaking, in the immigration context, final agency action means a revocation or a denial of an immigrant visa petition. This analysis can get fairly complicated if someone's in the United States under an adjustment of status application. DHS the Department of Homeland Security does have the ability to issue a notice to appear if someone is found to be, for example, their I-140 is revoked and they're otherwise in lawful status under filing an I-485. If DHS initiates removal proceedings, that can basically preempt and strike a federal court's jurisdiction to review an I-140 revocation. So Tom's going to discuss later on some important aspects of filing injunctive relief under the APA, which can sort of head that off at the pass, so to speak, before the DHS can act. But we'll get into that once we start talking about the case we're going to highlight. So where there's final agency action on an immigration petition, and the final agency action falls into one of 6 categories of error that are outlined in the Administrative Procedures Act. There can be a cause of action or a basis to sue the immigration agency under the APA. So we're only going to discuss 2 of the more common of the 6 categories of error here. Some of them are a bit esoteric and strange and involve rulemaking, for example, or unlawful rulemaking by agencies. We don't see that so much in our practice, but they do exist and they are out there. The two categories of error we're going to look at under the APA are pretty simple to understand. It's just where the government has made an incorrect decision in applying the law or failed to follow its own procedures. So the first of those is called when the agency action was arbitrary, capricious, and abuse of discretion, or otherwise not in accordance with the law. As many of you who are participating know from personal experience, USCIS gets the law wrong in a lot of employment-based immigration cases. We're not talking about a bunch of terribly sophisticated adjudicators at USCIS, and they've got a lot of cases, a lot of backlog. They don't have a lot of resources being allocated to them. And these adjudicators are being asked to serve as really a quasi-legal, quasi-judicial function in making decisions on immigration petitions. Immigration law is pretty complicated, and these folks, they get things wrong pretty often. And where they get things wrong, petitioners are offered and they're statutorily required to be able to respond to USCIS's allegations that something's wrong in the immigration petition. In most cases, this arises in the form of a notice of intent to revoke. Oftentimes, as immigration practitioners, we're able to resolve the issues that USCIS raises in the NOIR. But sometimes USCIS digs in its heels and it'll revoke the petition anyway. So where there has been a revocation and USCIS has dug in its heels, this is where the APA becomes a highly effective tool for challenging the incorrect or arbitrary application of the law used in revoking the petition. Some of you will be familiar with—
Jack, if I can interrupt you there for a second, there was a question that came in, and it's a very good question because it talks about, the finality. There are instances where a government agency, short of denying a case or short of revoking a case, or revocation, as you said, it's post-approval activity where the client thinks that the case is approved and that's that. But in a situation where the USCIS has not made a final decision but has issued a very onerous looking, very extensive request for further evidence, is it possible at that point in time to file suit against the government?
That's a great question, and the short answer to that is no. We've got to have final agency action. That's a pretty simple gatekeeping question. There's got to be a revocation or a denial in order for us to bring a lawsuit under the APA. There's just not really a good way around that. You just want to have a good immigration lawyer who's taking care of that stuff for you and making sure that all of the evidence that has been required by USCIS, either in an RFE or in an OIR, that's being effectively responded to. And as Tom will discuss, there's not, in more detail, there's not really discovery beyond the administrative record in APA cases, which means responding effectively to requests for evidence and notices of intent to revoke is really, really critical in establishing the administrative record, because once that case goes before the federal court, there's some exceptions to this, but they're pretty narrow. The federal court's review of what has taken place factually with respect to that immigration petition is limited to the administrative record. Right. So let's talk about a common example of where we're talking about final agency action that was not in accordance with the law. Some of the people in attendance will be familiar with this fact pattern, and it involves USCIS misapplying 20 CFR section 65612, which is a prohibition on employers receiving any compensation directly or indirectly for the cost of obtaining a labor certification. As most of you who are on this call, on this webinar will know, a labor certification is a prerequisite to filing an immigration petition in the United States. This statute prohibits any fees going to the employer. And what happens here is that once the petition gets to USCIS, USCIS adjudicators will look at this statute and say, okay, well, the immigrant beneficiary, the foreign national, is paid fees, for example, for an I-140 lawyer. And the misapplication of law there is, well, you've paid fees for an immigration lawyer, there's a contract with an immigration consultant, therefore fees must have gone to the employer in violation of 20 CFR 656.12. And that is a clear misapplication of the law. It's inaccurate, it's incorrect. And while, I mean, I can't even tell you how many of those I've seen, probably over 100 at this point. They just continue to get it wrong. They think it's some kind of a smoking gun, silver bullet type of legal argument. It isn't. Most of the time, we're able to resolve those matters and just an effective RFE response or an NOIR response. But again, as I said, sometimes USCIS digs its heels in on this stuff. And that would be a clear example of it's an obvious case of a misapplication of law. So if there was a NOIR response that was submitted explaining that USCIS had misapplied the law in this case and it had incorrectly revoked the petition, that would be a good case to file a lawsuit in federal court under the APA for. The second of the APA bases we're going to discuss here is that the decision was without observance of procedures required by law. As I mentioned earlier, petitioners of immigration petitions in the U.S., they're statutorily afforded the right to respond to allegations of deficiencies in immigration petitions. We're going to discuss this when we get into our recent case, but what took place and what is a good example here is USCIS just doesn't send notice to the petitioner that it has problems with the immigration petition itself. Or alternatively, it may send notice to the wrong address after a correct change of address filing has been made. This happens more often than any of us would care to think about in detail, but where USCIS doesn't give petitioners an opportunity to respond, fails to send notice, it's a clear case for an APA lawsuit. So let's talk about the next most important gatekeeping question. We've talked about final agency action, and then the two most common bases for filing an APA lawsuit, those being the decision was contrary to law or not in accordance with procedures mandated by law. So standing is the second biggest gatekeeping question that we have to look at. Article 3 of the US Constitution imposes a requirement on all plaintiffs bringing federal lawsuits that the plaintiff has to have standing in order to sue. I'm going to avoid giving a primer on Con Law 101 here because I don't think anyone's terribly interested in that. But for purposes of answering this question, whether it be as an immigration lawyer, answering the question of whether there is a potential case here, whether it's, as an immigration consultant trying to have a look at this stuff for your clients, it's pretty basic. Whether there's a case worth considering, it's really sufficient for our purposes here to know that where there's been final agency action and the immigration beneficiary has had their petition denied or revoked, we're likely to have at least an argument that they're standing to sue. Now, things get a little tricky when we don't have the petitioner on board. The petitioner meaning the employer. In most business cases, we're talking about the petitioner employer. So what happens, and what does it just make, can we not sue at all? What happens when the petitioner is not willing to be a plaintiff on the lawsuit? Can the beneficiary alone, can the foreign national alone sue? And like I said, things can get complicated here where the petitioner doesn't want to be a named plaintiff on the case. Ideally, in each case, the petitioner will be on board and will want to be a named plaintiff. And in that case, the standing question is pretty straightforward. But just as a lot of foreign nationals may be uncomfortable with suing the US government, so too are certain businesses, right? They think, am I going to get retaliated against? Is this a bad look for business? We've discussed that a little bit, and I think we've got a question here that we need to answer. But it can be uncomfortable for everyone when you're going after the US government in a public lawsuit in federal court. So in any case, leaving aside the question of retaliation for later, without the petitioner as a plaintiff, it's true that certain federal circuits hold that an immigration beneficiary doesn't have standing to sue individually. So we have to analyze this question carefully at the outset. It is different, the analysis based on which federal circuit that we have, that we're allowed to sue in under the venue rules. 4 or so circuits have favorable case law on this issue, while 2 or 3 have unfavorable case law on the issue, and the remaining circuits have little to no case law on the issue. For the lawyers in the room, you can imagine which circuits have favorable case law on the issue. We're in Seattle, so the 9th Circuit naturally, being one of the more liberal circuits in the country, if not the most, has favorable case law on the issue. If you have clients in the 9th Circuit, we're going to have a much easier time of this, say, than if we were having to litigate in Florida. And that's just sort of a general consideration when we're thinking about where we can sue and what kind of hurdles we're going to have to deal with in reviewing these cases. But importantly, the answer is yes. In many circuits, a beneficiary, a non-citizen, without the employer on the complaint, can sue the U.S. government for failure to follow rules and for a misapplication of the law under the Administrative Procedures Act. And in these other circuits, there's at least an argument to be made. I mean, the case law, even the unfavorable case law, depending on the facts of the case, it may be worth making an argument that the previous decisions on the issue were wrong for X, Y, and Z reasons. So depending on what the objectives of the individual client are, we may be able to just say, yep, it's going to be a hurdle, but let's file a case anyway and see if we can overcome the court's previous decisions on that issue. All right, so with the basics out of the way there, let's talk about this recent case. So in the recent case that we want to highlight, our client was in the United States lawfully, initially came into the United States on an E2 petition. He then filed an I-140 under the EB3 unskilled category. And because he was lawfully in the US at the time that his I-140 was approved, he also filed for adjustment of status. Now, this all took place around 2012, 2013. So our client's been in the US and living in the US and raised his family here for the better part of a decade. About 2 years ago, USCIS, according to its record, issued a notice of intent to revoke to the petitioner.
According to its position, I don't think that the record showed that they issued it. I just want to clarify that for those practitioners.
Right, because we did go and investigate whether or not it had maintained a record. And while we didn't get all the way there because we settled the case early, from the outward facing information that we could see, there was no obvious record of that. You're right. So yeah, that's absolutely correct.
They claimed, they denied it based on the claim that they had sent the notice, but they didn't say on the online website, case status website, that the notice of intent to revoke was ever issued, which is, I think, that due diligence that we did early on, I think that made a big difference. But sorry to interrupt, just wanted to point that out.
It's a good point.
Yeah.
So the notice to intent to revoke was sent, allegedly, right? And then the petitioner never got the notice of intent to revoke, so it never responded within the 30-day time frame that it would have to respond. So then the I-140 was revoked. Around a year later, our client got a notice of denial of the adjustment of status petition. That was the first that either the petitioner or our client had, the first time anyone knew that there was a problem with the underlying I-140 petition. So naturally, from the date that the adjustment of status petition was denied, then sort of chaos ensues, right? The I-140 is revoked. What do? We're in now unlawful presence because our adjustment of status petition has been denied, and we don't know why. So we had to do some investigating to figure out what indeed had happened. It didn't appear clear to us that USCIS had followed its procedures. As I mentioned, petitioners are entitled to the right to receive those NOIRs. But what made this case a little bit unusual is that the petitioner did not end up wanting to be a plaintiff in the lawsuit. They didn't want to participate. Fortunately, we were in the Ninth Circuit. The plaintiff was living in the Ninth Circuit, so we were able to have a pretty clear understanding that the plaintiff had standing to bring suit without the petitioner being involved. And we sued under the APA for failure of USCIS to follow procedures required by law. And that was a pretty clear case from our perspective. It's certainly possible that USCIS could have, and by its counsel through the Assistant U.S. Attorney's Office, that they could have, maybe they could have provided a record that they sent notice. We supplemented our complaint with affidavits of the petitioner's employer and of the petitioner stating that they had never received the notice that of the NOIR that they were required to be sent. So we worked up the complaint. We filed a motion for temporary restraining order. And ultimately, within 10 days of filing our complaint and our motion for TRO, and before any hearings were necessary, we were able to settle the case with the U.S. Attorney's Office. And USCIS reopened both the I-140 and the I-485 and ended up actually reaffirming the I-140 without, we had suspected that they would reopen the I-140 and then reissue the NOIR. And we were actually able to ultimately get USCIS to forego that and just reaffirm the I-140 altogether. So this case is just a really clear example of the utility, I think, of an APA complaint, particularly where someone is in the United States under an adjustment of status petition, and where there's an unlawful revocation, and we have things like unlawful presence to consider, where there's inadmissibility bars that might arise, et cetera. Ultimately, this was a really streamlined procedure for us to get relief for our client who was put in a really uncertain position. So that's the nuts and bolts of that case. And I think with that, I'm going to turn it over to Tom to discuss some of the basic procedural matters involved in litigating these cases.
Thanks, Jack. Assuming everybody can hear me okay. Jack had touched on originally the question of venue, where to sue. That's always an important preliminary consideration in any litigation, of course. Any APA suit is going to be filed in district court as well as any immigration suit. They're both federal question cases, both for a type of federal question case. It goes immediately to the district court. Venue for suits against the United States, federal agencies or federal officers acting in their official capacity can normally be brought in any one of three judicial districts: where the defendant resides, where a defendant resides, where a substantial part of the events or omissions giving rise to the claim occurred, or where the plaintiff resides if no real property is involved, which is typically going to be the case in an immigration case of any kind. So you've got some options in terms of where you can decide to bring your case, which raises questions, as Jack had mentioned, about circuit precedents, either with regards to the APA or immigration decisions, can be important since the circuits differ and their disposition towards these kinds of cases can differ. Also, dockets are an important consideration. Obviously, any federal district court that's any federal district that contains a port of entry or is near a border is going to have a significant immigration docket to deal with, which will mean a lot of experience with immigration law, but also possibly the necessity of the court as they see it to keep cases turning over quickly, which could affect consideration of individualized consideration of cases. The DC district is always possible for a case against the federal government. Obviously, they're going to have a huge body of experience dealing with administrative law, potentially less experience in immigration, but these are questions you're going to want to evaluate with an attorney at the outset of a case early on, an experienced litigation attorney. It's highly fact dependent in terms of where you're going to want to bring your case. And of course, as Jack had mentioned, with lawyers who understand this, with the beneficiary standing, venue can be decided potentially based on the side of the employer in addition to the petitioner themselves, depending on whether they're standing there, which could provide some advantage depending on where you get into court. Okay, once you've decided where to sue, we've got procedural considerations. Whenever you're suing the federal government, they're going to get 60 days to respond. Now, this is a large block of time, particularly if you have an NOIR or some other adverse action that may be taken and your client may be put into removal proceedings. There's a risk there that should USCIS commence removal proceedings, the case is going to be mooted and taken out of the jurisdiction of the district court, and you're in trouble. So the tool to avoid this is seeking immediate adjunctive relief in the form of a temporary restraining order and then a preliminary injunction to stop and stay any removal proceedings and to prevent the continuing accrual of unlawful time in the United States or other adverse action while the case is ongoing. So typically the way we have done this and the way we did this in the case that we've been discussing is you've prepared a whole package, including your complaint and an immediate motion or application for a temporary restraining order and for an order to show cause why a preliminary injunction should issue. Preliminary injunction is going to require a notice hearing after the defendant's been, or all of the defendants have been served, and a TRO, a temporary restraining order, can be issued immediately without notice. However, there has to be a showing, usually that's governed by local rules, as to what justifies the absence of notice before the court's going to grant a TRO.
To interject quickly, how important do you think that TRO was in our ultimate success in this case, because of the emergency nature of it, the speed with which the AUSA has to respond, et cetera? I mean, just generally speaking, outside of specific legal issues, just strategically and procedurally, how important do you think that was, and how quickly we were able to resolve that case?
Well, I was going to, thanks, Jack. I was going to get to that question a bit when I talk a little bit about interagency politics within the federal government, but I do believe that that was decisive because when you do have a TRO issued, any defendant, including the federal government, is going to basically have to drop everything and attend to it right away. And in this case, in pretty much any case, it's going to be the local U.S. Attorney's Office, wherever you've brought suit. They represent the federal government in all of these cases, but they don't necessarily have the same relationship with the agencies that the agency counsel would. So they've got to get right out in front. They have to contact somebody, typically either at the service center you're dealing with or in DC with the agency itself. So there's often a mismatch between knowledge and capabilities there that forces the government to move quickly. And this is a time when settlement can really be ripe, and certainly was for us, because we're committing the ultimate sin with regards to any government bureaucrat. We're making them work. We're making them work quickly. Okay, so after you've got your complaint and your initial TRO and preliminary injunction package together, you've got to effect service on the United States, which means in every case it's going to be the local U.S. attorney in the district, the attorney general at the Department of Justice in Washington, D.C., plus any agency or officer who's named in your suit has to be named personally. That's under Federal Rule of Civil Procedure 4I. In our case, we pretty much named everybody. USCIS, we named the Service Center, we named the Director of Homeland Security. I think we named Homeland Security as well. And we named all of the individual directors of these service centers and agencies. So basically sweep everybody up. Strategically, I think that's an excellent approach to take, where you've gotten as many different defendants involved and brought the case as much to everybody's attention, forcing quick action. The rules for getting either a TRO or a preliminary injunction are under Federal Rule of Civil Procedure 65. There is a lot of play in the joints under Rule 65. Certain things have to be shown. The content of an order, particularly a temporary restraining order, is governed by that rule. Rules on notice and the showing that has to be made with respect to notice, or which showing has to be made for the absence of notice, rather, for a TRO, is spelled out in that rule. But the play in the joints means that there are always local rules and procedures that are going to govern and very much going to control the outcome of what the court's going to do with the TRO application. Those have to be reviewed rigorously and painstakingly. Not only the local rules, which typically track the federal rules, you're going to have, for example, usually a local rule 65, which refers to the federal rule, but then also just the local motion practice rules, because when you are dealing with a motion for immediate consideration, like a temporary restraining order, usually there are specific procedures that have to be undertaken to bring that motion out of the normal order of consideration and off the normal calendar and bring it up for immediate consideration and action by the court. And these are typically all spelled out in local rules or in local court procedures. So that means getting on the district court's website and seeing essentially how each court wants to deal with these specific procedures. Local rules are also different everywhere. They very often follow local practice in the district that's used in state courts, just simply for the convenience of the local bar and local litigation bar that gets into court, both in state and federal courts, to the extent permissible under the federal rules and federal statutes. So it's something, especially in this area, where you're looking at potentially multiple different venues, practice in many different districts. Practitioners need to stay on top of this and always need to look at the local rules and local procedures first, look at them early in a case, look at them at the outset of the case, and make sure that they inform your timeline and task planning. Litigation staff and case management software need to be set up to keep track of the rules, the timelines they set up, and the required showings. Both Rule 65B, dealing with TROs, and local rules as well are going to regulate what kind of showing you have to provide to a court. In our case, we had to lay out very specifically why normal notice couldn't be given, the necessity of the court undertaking immediate action here. We had to do all of these things before we had a properly formatted TRO application that the court was going to act on. And again, as I said earlier, in terms of pretty much the iron law of bureaucracy, in terms of making even courts work, they're going to look for any opportunity that is out there to not do what you want to make them do, especially when you're litigating against the federal government. And non-compliance with either the federal rules or local rules is an easy way to get the courts to do nothing while your client's case just ticks on towards a potential adverse action by USCIS.
Tom, let me ask you this question, because this has come up, and I'm not sure if this is the right time to discuss this, but given that we have attendees from other parts of the country, the question was, if I'm in Michigan, You know, how do we go about, you know, is this limited to the Ninth Circuit? Is it limited to California, Washington, where you are licensed to practice? How does it work with representing individuals if they are out of state? If you could speak to that, because you are talking about local rules, so I thought it might be a good idea to talk about, you know, how can we represent clients outside of just, you know, where we practice, where we operate?
How can we represent clients outside of, just where we're specific? Okay. I mean, typically in those cases, that would be an application to be admitted pro hoc vice. So find local counsel who can sponsor in a particular jurisdiction. I believe we have counsel who are admitted in Michigan in our firm. One nice thing about the federal system is the federal rules are, the highline federal rules are the same everywhere. And we're dealing with federal question litigation, so the statutes are going to be the same everywhere. As far as the local rules, those just vary with respect to any court. So in litigation, anywhere you are, that's always a consideration. I mean, even if you're practicing in a different county within the same state, you very often are going to have to look up the local rules. So it's just a consistent theme in litigation that you always do at the outset of any case, just because they vary everywhere. It's just a standard kind of practice in litigation. So I think that it gets, you know, folded into that. Does that answer the question?
Yeah, I think the question was from a non-lawyer, is my guess, because, you know, this concept of pro hoc vice, you know, having another attorney in another jurisdiction kind of file a suit, and then for you to be admitted, or for you to enter as the attorney in that particular suit, that the fact that that tool exists, unless you're practicing, you know, or unless you're a lawyer or litigator, it's generally not as well known in
It's also worth noting too there that, like, somebody may be, for whatever reason, in Michigan, but their case may be processed by the California Service Center. And so under the venue rules, we could certainly file suit in California under that circumstance. So yeah, the options are not necessarily just in terms of where we can file and what local rules would therefore be applicable. There can be more options than it may be obvious that there are.
Correct. Yeah, exactly. From a lay perspective.
And that calls for what I said, sort of the initial review at the beginning. It's a question of strategy when you have options as far as venue, where you want to sue. Sometimes just experience with a particular forum can be decisive there, or sometimes local procedures and rules can provide advantages to, you know, to particular cases. But that's something where, you know, sort of review with an experienced litigator is going to help you out there. Okay, so I'll move on. The timeline here, it's, as I mentioned, it's 60 days to answer a complaint. Getting a TRO you can get at the outset of a case, a temporary restraining order, but those are only effective for up to 14 days. So you would have noticed within those 14 days a preliminary injunction hearing, which hopefully would freeze the entire you know, case, essentially maintain the status quo, including adverse action by USCIS until the conclusion of the case. So TRO is good for 14 days. A preliminary injunction is up till the end of the case, judgment, settlement, whatever the case may be. If the case doesn't ultimately wind up settling, you know, then we're moving into motion to dismiss, summary judgment, all of the particular other remedies that can come up in federal litigation to resolve the case short of trial, which is going to be fairly uncommon. Sorry, Jack, were you saying something?
Nope,
Okay.
I'm good, Tom.
Okay, sorry, I thought I heard you saying something. Yeah, so, okay, I was saying that that window that we have for settlement in our case that we were dealing with, as soon as we had filed for the TRO, that's when the government wanted to talk. And that's when they got on the phone to agency counsel in DC. And this was, you know, a local U.S. attorney's office that, you know, didn't know anything about the case, but they are getting served, you know, immediately with, you know, lawsuit, complaint, temporary restraining order application, motion for order to show cause for preliminary injunctions. That's a ton of work for them, and they have to turn around negotiating with agency counsel to move forward with this. Okay, so getting into discovery. Discovery in these kind of cases is going to be, discovery and facts outside the record is going to be very limited in APA proceedings. The Administrative Procedure Act just limits the record to the court to what was available to the administrative record that existed on file at USCIS. However, some declarations from parties, petitioners, the immigrant, whoever, can be allowed in certain instances. In the case that we were discussing, we were able to get declarations from the employer and their lawyer that they didn't receive the NOIR and NOR. Because those are procedural issues rather than the substantive issues of the underlying case, we were able to get those in because the key difference is that in an Administrative Procedure Act case, evidence as to the procedure or the compliance or non-compliance with procedure can get in, whereas the record itself as to the substance of the matter is frozen. So we can introduce evidence as to the defects in procedure, and that's how we got that in.
If I could just say one thing over here, is that,
Sure.
as the, at the time of filing the immigration benefit, it's really, really important to establish a very good record. Oftentimes we see cases where things are just, documents are thrown together. But if you go through the painstaking process of putting together a good record, knowing that the case will, kind of be dependent on this record later on, if it ends up going into federal court, it's important to kind of explain why the documents are being included, the relevance of those, and that way, if tactically it's like a chess game where it's that initially if it's adjudicated without any hesitation, without any resistance, great. But after that, if we need to go into litigation, that record from the get-go is going to be your savior, oftentimes. But yeah.
Right, and that's something you need to also be thinking about preparing at the outset of the case, getting the declarations you need together, getting the documents together, having them reviewed by your witnesses and getting them in. That was pretty decisive in our case, getting all of that together and prepared early on so we could put it all together. The standards for also getting the TRO or preliminary injunction are likelihood of success on the merits, showing of irreparable harm, balance of equities tipping in favor of the movement, and it's in the public interest. We were able to show all of those, particularly since we had a fairly clear-cut APA case where no notice had been given. Obviously, removal from the United States and inability to apply for residence in the future is irreparable harm in this case, especially since USCIS had completely dropped the ball on notice. And our client had done nothing wrong. Balance of equities tipped very strongly in our favor. Public interest is satisfied by having USCIS comply with its own rules like any agency. Do we have time to kind of delve a little bit into interagency politics? Did we want to talk about that?
Maybe if we want to take a couple minutes on that, I had another question pop up.
Sure.
It's about retaliation. So I do want to get to that. And there's a question on mandamus, difference between mandamus and APA. I think both of those are worth discussing, but you can go ahead and talk about interagency policy because I think it's relevant here. It's important. You touched on it earlier, but yeah, go ahead.
Yeah, there is usually sort of a skills and knowledge gap between U.S. attorneys' offices, local U.S. attorneys' offices, and agency counsel. U.S. attorneys typically, and assistant U.S. attorneys very often tend to be, often skilled generalists. Especially in a smaller district, they're going to get into court a lot. They're going to know local procedures. They're going to be kind of the one riot, one ranger that shows up when something like a new complaint with a TRO comes in to the office, but they're not necessarily going to be as familiar, depending on where they're practicing, what their past experience is with, for example, immigration law or agency procedures. They may or may not be. And they certainly are not going to be familiar with the facts of any specific case that was handled by a service center maybe halfway across the country. So they're not going to be as cognizant and familiar with the facts as the agency counsel or agency staff would be. and they're getting dragged into court right away. They have to interface then with agency counsel, probably in DC, and also agency employees and officers who could be anywhere. So there is some friction within the government and some interagency politics at work there that can really be you can use to your advantage, because the U.S. Attorney's Office has got to do something quickly. You're going to want to get cooperation from the agency quickly, and everybody's got to move quickly. And possibly nobody's going to know at the outset within the government who's needed and what records are needed and how they're going to deal with this particular case. So I thought that was decisive in our case, where we did have one particular AUSA in a local district that doesn't handle a large volume of immigration work suddenly get this case, and then they're having to deal with USCIS in DC and at the service center in Texas, so all over the place. It led to a quick determination. Now, they do have to defer to agency counsel as far as agency policy in terms of what they're going to do. But I think very clearly there's pressure that kind of pulls both ways there, that can, lead to a lot of pressure for an early settlement if you can get that pressure going.
Thanks. Jack, do you want to take this question about, we've talked about APA, and I think, for those who joined a little bit later, we did mention that, APA and mandamus are different. We're not going to talk about mandamus. That will be the subject of perhaps another webinar. But can you talk a little bit about the difference between the two?
The biggest difference is that a mandamus action, you can file it for unlawfully withheld action by an administrative agency or unreasonably delayed administrative action. That's a highly fact-specific determination. But functionally, a mandamus action can't overturn wrongfully decided action, and that's what an APA case does. Mandamus just compels USCIS, say, if you've got a case that has no priority date or backlog issue, and it's been sitting at USCIS for longer than stated procedural timelines from the government, you can file a suit in federal court and basically ask the court to just order USCIS to make a decision. But people need to know that there is risk there. Insofar as whatever that decision is can be unfavorable. So you want to make sure that whoever, that all of your, the immigration work itself was really quality work. Because if USCIS reviews that and finds something to complain about, then that case is going to turn into a mess. They'll just issue a NOIR, and then you're right back into, you basically wasted money filing the suit, because now you're back in the NOIR responses can take over a year. It's just, it can be unhelpful. But ultimately, mandamus just compels it. Court's just saying, USCIS, go ahead and make a decision on the case. APA action resolves errors and omissions by USCIS in the actual adjudication process.
Yeah, and that segues nicely into, just a minute I'll take about this. The mere act of filing the lawsuit, that itself will not, the USCIS will not retaliate, or the Immigration Customs Enforcement is not going to retaliate unless there's, there's something in the case that is deficient. But at the same time, it's also important to know that the timing of this, and especially as Tom mentioned, that given that, if removal proceedings start, then the case can no longer be in federal court. So asking for injunctive relief to prevent that removal proceeding from starting is, that tactical awareness is super important. And being able to request that from the get-go, essentially you're putting USCIS and DHS on notice, saying that, look, we know that you could start removal proceedings, but we're going to argue that they are not authorized over here. And then the last point I want to mention about retaliation is that, many of our clients come from backgrounds where speaking up against the government results in a lot of reprisal. And, the American legal system in that sense affords certain protections. And, when you file a claim, when it's based in law and fact, when you have made the arguments from the get-go, it allows for you to stand up and get justice. And that's what this is about. It's about equity. It's about going to a third party, a neutral party, and asking for justice. So that's the reason why lawsuits have risen, and they are an excellent tool. I know we're at time, and I know we have other questions, but I think that we're gonna end this particular webinar here. Is there anything else you wanted to add, gentlemen?
If anybody has further questions that we didn't get to, feel free to get in touch with us. We're happy to answer them offline.
Thank you, everybody. Thanks, Tom, Jack.
Thanks, Akshat. Appreciate it.
Thanks, Akshat.